Hello again, I'm still here. I'm attorney Robert Flessis for Robinson Lloyd Career Training Institute. In the last video, part 1, I discussed the inspection contingency and the interrelationship of the condition report, property condition representations, the definition of a defect, and the inspection contingency. In this video, we're going to discuss what you need to know and do if the offer contained an inspection contingency and the property inspector discovered a defect. Specifically, we're going to discuss the difference between a notice versus an amendment when a home inspector discovers a defect and the buyer wants to object. First, we need to talk about the definition of a defect. There are two things that go into that thought process. The first consideration is this a bona fide defect according to the definition of a defect? The second consideration is, did the seller disclose the defect in their property condition report? That's why we need to look at lines 210 to 211 of the offer to purchase. Those lines state, quote, "For the purpose of this contingency, defects do not include structural, mechanical, or other conditions, the nature and extent of which buyer had actual knowledge or written notice before signing this offer." Well, what does this sentence mean? It means that if the defect was disclosed in the seller's property condition report, the defect is not something that a buyer can complain about because they received the disclosure of the defect prior to performing the inspection. Well, what do you do if the buyer is aware of a defect prior to an inspection? You use lines 196 to 199 of the inspection contingency for the purpose of allowing further inspection of the disclosed defect. That covers your buyer. They're telling the seller that they're aware of the defect, but they want to go further by hiring an independent inspector to take a look. Now, if a defect was not disclosed, then the inspection contingency requires the buyer to provide a notice of the defect to the seller. What are you required to do according to the terms of the offer and your obligation to follow the law that regulates you as an agent? Your buyer wants you to let the seller know that a defect is present and there must be some resolution before proceeding. To do that, you need to provide a written notice to the seller of the defect or defects that were discovered and were set forth in the property inspector's written report. When you look at an inspector's written report, you'll notice that the inspector flags each potential issue with the label defect and the evidence of the defect and why it's a defect. But I'll discuss this in the next video. When you deliver the notice to the seller, you also have to incorporate a copy of the inspector's report that points out the defect and contains the reason that it qualifies as a defect. That's what you need to do for the buyer. Anything less than that demonstrates incompetence as an agent and can subject you to discipline by the DSPS. The terms of the boilerplate approved WB11 offer to purchase states that in order to give notice to the seller, you need to use a what? Approved form. That's how you provide proper notice. What approved form do you use to provide notice to the seller regarding a defect? Is it an amendment to the offer or a notice of defects? You should know the answer to this one by now. You first have to use the approved form that's called a notice relating to offer to purchase to the seller. That is approved form WB41. The offer to purchase specifically alerts you as a licensee by stating in bold print, gigantic, on that part of the offer, caution. A proposed amendment is not a notice of defects and will not satisfy this notice requirement. Well, blowing off the written notice and going straight to an amendment is not the correct way to deal with defects, at least in my opinion. Now, from my experience, I've seen agents failing to provide a notice to the seller. You can provide the amendment, but you need to give the written notice first to meet your obligation under the offer to purchase. Well, some of you look confused by all of this. I could see that. Let me give you an analogy that may clarify the theory of notice. This notice is similar in nature to what is required in any civil or criminal legal action. If you want to sue someone, say in a civil court, you have to provide notice to the defendant that they're being sued. The notice is attached to the complaint, which gives the defendant notice of a lawsuit, and the complaint provides the reason why they're being sued. Same thing applies if you have been accused of a crime. You have to be notified that you're accused of a crime first in order to defend yourself, right? That's only fair. A plaintiff in a civil action can't just start the lawsuit without notice to you and proceed straight to a trial. A state or federal prosecutor in a criminal action can't bypass the notice requirement and go straight to trial either. You won't know what you're being accused of without proper notice. You have the right, though, through our Constitution, to receive notice and the right to be heard and confront your accusers. This theory is also true with the rights you have that are contained right in the offer to purchase. When I analogize the notice in civil and criminal cases, this is similar to why you provide a notice relating to the offer to purchase directly to the seller. You're telling the seller that you have a problem with a defect. That notice satisfies the requirement in the offer to purchase to commence negotiations with the seller. The notice must first be delivered to the seller according to the offer, because the seller has the right to know what you're complaining about. If the buyer doesn't give notice, then the seller has no idea what you're complaining about. Delivering just an amendment without a notice does nothing. You may try and state in your amendment the defects that your buyer is complaining about, but that amendment doesn't qualify as a notice, period. What are you going to do for the buyer when you draft and deliver a notice to the seller? Well, let me tell you what you're going to do. You're protecting the interest of your buyer by getting the notice. When an agent doesn't prepare and deliver a notice to the seller, as the agent, you're taking a big risk by blowing off the notice. You could be sued by your buyer if something goes wrong. Well, what could go wrong? You're probably asking yourself right now, right? I'll tell you. Let's say you delivered only an amendment and the seller doesn't accept it and the inspection contingency expires. Well, you just made a big mistake that could affect your license. First, you didn't follow the terms of the inspection contingency in the offer. Second, you denied your buyer the right to pause the offer and keep it in full force and effect while you negotiate a remedy to the defect with the seller. If you didn't deliver a notice, you could have caused the buyer to lose their right under the contract, especially if the buyer really wanted the property. If this happened, you would more than likely have a complaint filed against you for being incompetent by failing to perform your duties under the contract as a licensee. Well, that's where the DSPS steps in. You don't want to go there. By proceeding directly with an amendment rather than a notice, you're not providing notice. You're only proposing a remedy. The seller could reject your amendment on the basis that you didn't provide notice and you didn't provide a copy of the inspection report. The seller could also reject the amendment under the theory of that you knew about the defect before performing the inspection without providing for any other type of specific inspection. I hope that you appreciate the difference here in the two documents and the importance of delivering a notice first. Very important. The notice requirement is critical. You're not only protecting the buyer, you're protecting yourself from liability. If you screw this up, what's the first thing that the buyer is going to do? They're going to reread the terms of the offer to purchase, and they, or their lawyer, will be able to discern as plain as day that you missed an important requirement that you failed to abide by, exposing your buyer because they relied on you to their detriment. Reliance to your buyer's detriment is the key phrase here. It's as simple as that, and it's actionable by the buyer through their lawyer. I know why some agents bypass the notice and deliver an amendment rather than a notice. Their logic is the buyer wants the home, but the buyer isn't going to proceed with the deal if there's no contribution by the seller to remedy the defect. Your buyer wants a reduction of the price or contribution to cover the remedy for the defect, right? So in dealing with your next offer, remember the difference between a notice and an amendment. If you forget what I've discussed with you, then you reread the offer to purchase terms when it comes to the inspection contingency and defects. It's not a bad idea to have a procedural guide that you can refer to. It's kind of like a checklist that you follow with each offer that you prepare. The checklist will also help you when it comes time to explain to your buyer the difference between a notice and an amendment, but I don't think they care because they want you to do your job, right? Checklists work well. Lawyers use checklists all the time. It keeps them from creating liability for themselves. You can keep the checklist on your computer for future reference. It will then be easily accessible to you for future transactions. Well, this concludes part 2 of course number 4, and I'll see you in the next video.